So two follow-ups that are related to marijuana, we can address those. Somebody asked the question about what's the proper spelling of marijuana. So if you look at all of the federal statutes refer to it with a H. Then when the initial state law initiative was put in place in '08, also in the 2016, they spelled it with an H, and then everybody else spells it with a J, and the question was, what's the difference? And the most is interesting, I just a week ago heard from the director of the Bureau of Marijuana Regulation, and he was indicating that he would have actually preferred that they had spelled it with a J because he gets so many emails, comments, and actually calls every week from people asking why did they spell marijuana wrong on their website. So the interesting thing, they used to have a disclaimer on their website which basically explained the origin of marijuana spelled with an H, marijuana spelled with a J. Their basic premise was federal law was spelling it with an H, we're going to do the same thing. Now they've taken the position that they can't change state law, obviously, and they can't change the voter-initiated legislation, so they decided to make it one step more complicated, and on their website and in their own forms, they would spell it with a J, but when they refer to the state law, they would spell it with an H. So now, to hedge your bets, they've spelled it both ways. The other question then that Matt related to the issue between this interplay, right? So we get a lot of questions about the interplay between the 2016 commercial recreational statute and then the voter-initiated 2018 statute, and how adult use, the licensing of those facilities, interacts with municipalities that have already opted in or allowed medical marijuana facilities. And so the question basically comes down to, if I've already opted in, I'm allowing facilities and have facilities operating, and I have not yet made a decision on recreational marijuana, or if I have prohibited them, can recreational facilities automatically operate in my township, right? So basically, if I opted in to commercial medical, can recreational facilities come in and operate?
Unfortunately, the answer to that question is we don't know yet. The first thing I would say is that if you're allowing recreational establishments, you do, under that process, you can require a separate application. You can require a separate application fee and push that right. So if you're allowing it and they're saying, hey, I've already have a medical one, that's good enough, you say, no, this is a completely different law, and look right here in this statute under Section 6, I get another $5,000. So that's step one. But the more interesting and potentially problematic question is, when you already have your medical facilities, you've allowed potentially a few facilities, you see some medical benefit, but there's an argument under the way the language was written that a grower, processor, or retailer can co-locate with any existing marijuana facility. Well, so okay, the idea, what we think the intent of this was just to allow some co-location and to try and keep some economies of scale, right? You don't want a recreational establishment right next to a medical establishment. That just wouldn't make sense. We'll put them in the same building. But the way they've drafted the language, now we have a conflict with the township's right to prohibit them entirely. And until we've seen a rule come out of Lara and potentially some litigation over someone trying to force the issue, it's not exactly clear which provision there is going to control. So what we would recommend you do, if you don't want them, if you have facilities but you don't want the recreational establishments, is to pass your ordinance prohibiting the recreational establishments, and then hopefully we'll get some guidance from the regulator and kind of massage and control that as we see this language get interpreted and actually put into use. But it's going to take some boots on the ground and people putting things in place before we really know how that language is going to be used. And hopefully it'll be used in a local advantage, and we think we have some strong arguments that we can deploy in your favor to help continue and contain those land uses.
And the practice pointer there, too, just to add on, if you're somebody who has a medical marijuana licensing ordinance and you're allowing facilities, since there's potentially this where we would have to basically wait for a court case to rule on this conflict in the language. What I would suggest you do is, if you do prohibit recreational facilities, at least include something in your statute that would indicate if for any reason under state law or otherwise recreational facilities were permitted, they are subject to the same rules and regulations of your medical marijuana facilities, right? Because the worst thing you'd want to do, prohibit it, have somebody declare that those facilities can go in, and then they're not subject to any potential regulation other than state licensing. So you could at least subject them to your ordinance or your medical marijuana ordinance, and then we could go back and at least fix it from there.